Hey, Mr. Thomas, let's call you up and let's move you along here. This is People versus John Thomas, 26M311, 26M376. Mr. Thomas, there is a warrant, or actually a couple of warrants for your arrest for failure to report to pretrial. We'll cover that in a second. You can have a seat. It's fine. Maybe they were resolved. You were arrested, so they're no longer pending. Have you reported to pretrial, Mr. Thomas?
Hey everyone, welcome back to the channel. In today's video, we're diving into 4 different court hearings featuring 2 absolutely delusional sovereign citizens, all kicked off with a quick intro. Let's get right into it.
Mr. Holt is present in custody. He's scheduled for preliminary hearing. How would you like to proceed?
I filed a motion for a competency evaluation.
That's right.
May I ask you a question, Your Honor?
You may, but first let me explain something to you.
Yes.
We are recording everything that is said here in the courtroom, and anything you say about the charges you're facing could be used against you
I understand this, Your Honor.
by the prosecutor. One of the reasons the state of Colorado gives you a court-appointed attorney is so that you could speak through your attorney.
Right.
I'm happy to give you a moment to whisper with your attorney.
I'd like to see if I could be released on my own recognizance pending the outcome of the case. It was like $3,000. I have, or what was it? I have the money on my debit card that's in Carrie Matthews has on her person, but I'm looking for a reduction in that, being that the case is not so egregious as perhaps egregiousness is. There was no threats. The weapon, the alleged knife. All right. I would, if you could consider a reduction, sir. What's the amount now? 2,500 or?
So the other complicating issue with bond is that he has a parole hold right now. I've reached out to the parole officer. They're not willing to lift it at this point, but we're going to keep trying. And so we've talked about sort of addressing that once we can get it lifted.
But I've heard that the sentence doesn't merit, it doesn't look like any menacing was even there on the cameras at Hope's COS. And I would like the reduction to ROR. This does happen in this county where people do get ROR'd, and then pending the outcome of the case, if I'm found guilty, then I could go back to jail and then go to DOC. But I feel it's warranted that I could get the ROR. And if it's so much, it's on the debit card, and I could pay for that with Miss Matthews sitting in the back there.
In some cases, it is warranted, but in your case, it's futile because of the parole hold. And so I'm not willing to address it today, but if the parole hold gets lifted, then I'm willing to address it in the future.
I understand, Your Honor. I appreciate that.
Okay, now your attorney has raised the issue of whether you are competent to stand trial. And what this means is that I'm obligated by law, if I find good grounds, and I am finding good grounds, you're going to be evaluated by a psychologist. And this is going to delay the proceedings. And you have certain rights associated with this evaluation.
Yes.
If you will bear with me, I would like to read you those rights. And when I'm finished reading you those rights, I'll ask you if you have any questions.
Yes, Your Honor. God bless you. I appreciate your levity and allowing me this moment with you. And I realize in the United States, the judiciary is, in fact, they bring kings and queens, heads of state, senators and congressmen to trial because the real king is, and because the heads of state cannot do it, the judge themselves. And for instance, the district attorney is like is like the you're the sire the king and they're sirs of the court, and they're also esquire. And so it's a parliamentary procedure is used, and it's a exercise in royalty.
Judges aren't kings. Prosecutors aren't rulers. But right now, you're not in a position to make demands, and you're definitely not being released on a PR bond due to that parole hold.
I can appreciate your largesse, and I know you have a lot of power. You know the state judiciary and you know the federal judiciary. I just felt that people are after my life for being a Jewish American, and that it was contained in my pocket, and I just asked for a little mercy and your fortitude. And the Roman Empire is you in one person, because I'm also of Germanic descent, and so I asked that you could please see the tape at Hope COS yourself, and it was in the, if you could have a little mercy on me, it's just a parole violation. And even if I did spend time, it'd be 6 months. Wouldn't be that much. It's no big deal, but I'm trying to put my life back in order in the street. I could avoid doing the 6 months. I've already done a year and a half. It can't start over again. It's a 3-year tail. So the most it would be in a year and a half, but then I should be customarily the year and a half tail is pretty much the rest of it is exonerated, having done a year and a half anyway. So, but being that I've, for 6 months, all this, it takes quite a lot of the state's time and money to prosecute crimes with anywhere you go in this country. Is it really worth the court's time? You have a lot of egregious offenders, sir. And you are a king. You are a king. And the yellow fringes mean admiralty. We come from England, the bastion of common law. The Roman Emperor Justinian himself, being of Germanic descent, because, for instance, the law of stare decisis, common law, the Codex of the Roman Emperor Justinian, and a lot of German blood is actually, and England wouldn't be that way without Germany. So understand that Germany has civilized the world with common law, and Israel still uses civil law. Shoot. So, that's the reason why people use the straw man. That's wrong. What it means is that, believe it or not, I don't even think the world's coming to an end. It has many years to go. But, I personally have faith, and I believe goodness wears out or has the end of the day. But it's just going to be a real warm summer, the southern sky. It's going to be on average warmer. I just don't want to sit and waste the whole year in a cell. I'm willing to be conducive enough to handle myself appropriately.
So, Mr.
I just don't like the Aryans in there.
If you don't want to deal with Aryan gangs in prison, then the answer isn't complicated. Don't commit new crimes and don't violate your parole conditions.
Hang on. I don't blame you. Let me share.
Aryan nations, yes, forgive me, officer, please.
Mr. Holt, I have the floor now.
Yes, sir.
You're only allowed to speak when I give you the floor.
Yes, sir, Your Honor.
So I need you to listen to me.
Yes, sir.
It is a warmer than average year. And in an effort to maximize your chances of getting out into the warm weather, I need you to listen to this advisement.
Yes, sir, Your Honor.
And then when I'm finished reading it to you, I'll answer any questions that you have.
Yes, sir.
So because your attorney has raised the issue of whether you are competent to stand trial, this means that you will be evaluated by one or more psychologists or physicians, and you have certain rights throughout this procedure. You will Since it is the defense that has raised this issue, this constitutes a waiver of privilege to any previous or subsequent competency evaluations. You have the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine your competency. Any statements you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify at any subsequent criminal trial. Any statement you choose to provide in cooperation with the evaluation may be used at any sentencing hearing held in the case if you are found guilty. You have the right to request an evidentiary hearing to contest any determination of competency. You have the right to be examined by an expert of your choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At such hearing, you have the right to be present in person to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court. You have the right to introduce evidence, summon witnesses, cross-examine opposing witnesses, or witnesses called by the court, and you have the right to make an opening statement and closing argument. If you are found incompetent to proceed, then the criminal proceedings would be suspended, and you will be committed to the Department of Human Services for a period not to exceed the maximum term of confinement that could be imposed for the offenses with which you are charged. If committed, you have the right to request a hearing as to whether your competency has been restored. If you are found to be restored to competency, then the criminal proceedings will resume. Do you have any questions for me about any of these rights?
Thing first means I celebrate Germany because primarily the tribe of Judah is Germany. When the Arch of Titus Caesar went, they were taken to Rome, in which mostly is Germany. And so the Pax Romana is Roman law. The civil disabilities bears the hallmark of, well, let me just say, a German brutality, but it's not brutal. How do you stop all crime in Rome? Simply, people are reduced to pauper status. You can't vote. You can't have a job. You're nothing. You have no money. And see, I personally believe nobody does it like Germany, because England would not be England without Germany. Saxony is a part of Germany. So, I have Merovingian blood from Joseph Francis Holt. If you want to know the truth, John Southern, John Wayne is John Holt, and he is my real father. Ann Holt is our grandmother, and my great-grandmother is Anna Majuk. Her brother is Bob Barker and stuff, and she never really got. And so my mother's it's a good person, and her husband or husband or second husband is the Brigadier General Anthony McAuliffe. I'm well known to the government.
Mr. Holt,
I will say, sir,
I'm taking the floor back from you,
Yes.
so you have to stop talking now. I'm ordering the Department of Human Services to conduct a competency evaluation of you. As soon as we get that report from the psychologist back, we'll bring you back to court. I'm going to review this matter in 90 days. That date will be? Good luck, sir.
God bless you, Your Honor. Thank you. Have a great evening.
All right, that wraps up his first appearance. And yeah, it's not looking like John Wayne's son or Bob Barker's nephew is getting out anytime soon, especially with that parole hold hanging over him. Now, let's move on to his next appearance, which is shorter, but just as delusional as the first.
All right, I see that Mr. Holt is present in custody. How would you like to proceed?
I'm covering on behalf of Ms. Daly. In my notes, I have that Mr. Holt was just found incompetent to proceed but restorable. We would ask for an in-custody restoration. We'd also be requesting a Bridges liaison. And I'll stop there.
She's saying stuff like, with levity, sir, not parody. Parody means I'm on par with you, and that would get me tossed from speaking. Levity means a little level. She's trying to talk over me. I don't know what the heck she's talking about.
Oh, stop and just listen.
Yes.
Mr. Holt, I'm going to give you the floor in just a moment. Right now, I'm listening to your attorney, so hold that thought and stand by.
Please forgive me, Your Honor.
You were saying?
And then we'd also be requesting that this case is sent to the competency docket as well.
All right. I'm going to grant that request and order DHS to undergo restoration treatment for Mr. Holt. We will review this matter, or I guess DST will review this matter. Ms. O'Rear?
Yes, Your Honor. The people would be asking that this case stay in Division 21. It is a VRA case, and so just by office policy, we've been trying to keep those in the division to lessen the load of the work that the competency docket prosecutor needs to do, since there's often motions issues, bond protection orders, things like that. So the people's request would be to keep it in Division 21.
Ms. Kovach, what do you think of that?
Judge, my notes simply reflect we'd be asking for competency docket. I just think they're better suited to handle this case with Mr. Holt. And so that's our position.
I'm going to grant the prosecution's request and keep it in Division 21. So we're going to review this matter in 90 days. That date will be?
A little bit longer because that's vacation. So June 2nd.
June 2nd at 8:30 for review. Now, Mr. Holt, what is it you wanted to say to me?
May I stand up while I...
You may.
Okay. For instance, Shire is a township of in the English language. It's a beautiful thing. The Shire is like a township, and he was also a sheriff in Old England, whereas the King of England couldn't do that stuff, so he had the local sheriff do everything. The Crown Prince is the district attorney, and well, women could do it too. They say there's no women preachers, but there is. So technically, it's all. For instance, there's no 3x5 cards. It was all just word of mouth, and maybe 3x5 cards. Very few people, if ever, do this type of thing. And so. The yellow fringes on the flag mean it's under admiralty law of England, because we come, all the bastion of law comes from England. The English people are very beautiful people. In fact,
Mr. Holt, I'm sorry to cut you off, but
let me just say one thing. Would I be released? What was she saying in effect in her legal speak that am I released pending care with I say Hope Springs Grove is a very good place, but what is the extant plan going on?
I'm appointing a Bridges liaison who is someone who can assist with your needs while you're undergoing restoration treatment. When you talk about the English law and American law, they're going to be discussing those topics.
Common law is better than anything.
I agree. And they're going to be discussing those ideas with you in the classes they're going to send you to. I'm going to review your case in 90 days to see if you've been restored to competency. And we can finish this conversation at that time.
But would I be released in care of Hope COS or?
Not now.
All right. What happened is I got a lawsuit that's going to net me multi-billions of dollars.
Sure. And you're going to need to let that lawsuit take its natural progression.
All right, Mr. Holt, go ahead and exit.
Thank you, Mr. Holt.
All right, so the future billionaire will be staying in custody while he's restored to competency, and after that, he'll have to face the charges against him. Before we move on to the next case, it's worth pointing out that sovereign citizens often get their information from so-called gurus, people who push misinformation without any real consequences for the damage it causes. What sounds completely irrational in court is often just someone who's been seriously misled. Now, let's move on to our next character, who's clearly bought way too deeply into conspiracy thinking.
So, I appear under duress.
I'm sorry, I didn't hear what you said.
I just showing an appearance under duress.
Okay. This is People versus John Thomas. 26M311, 26M376. Mr. Thomas appears. I have a note from the court that He has a warrant, which I knew, and he wants to address pretrial supervision. Well, let's talk about the warrant first. I presume you want me to quash the warrant, Mr. Thomas.
Yes, sir. I think quashing the warrant is actually pretty mature, considering that the appearance bond, I never agreed to the consensual.
Well, I can remand you, and you could be in jail.
Well, no, it's not that, Your Honor. It's the fact that I'm a secure party creditor with the Secretary of State, and my policy's been tampered with. And unfortunately, right now, I filed criminal charges with the United Nations and also the Secretary of State. I think all my court cases are even under investigation at this point in time.
That's great. Okay, I'm good. But this is my case, okay? And the charges in this case are violation of a civil protection order in one case and violation of a criminal protection order in the second case. My guess is that the violation in the criminal protection order case is based upon the bond appearances, the bond terms in the first case. And I'm looking right now. But I ordered you to pretrial, and if you don't want to do pretrial, that's up to you. But then I'll remand you. And
no, my mom filed a motion into the court. I think she's got court on the 17th. She didn't realize there was a restraining order against the two of us. She's almost 80 years old, and so I take care of her and my dad both. And unfortunately, the day that the officer showed up over there, I was 2 yards down in the house. They were trying to basically rake the leaves, and of course I burned all the weeds and stuff. Well, one of the neighbors came out and kicked the fire out in the street, and they basically told me to go over to where my camper was. So I stood over there at the officer's word, and then they said that I had a mental health situation. So the ambulance showed up and did multiple tests.
let me hold you off, Mr. Thomas. I want to reference Mr. Broughton to a case.
Okay.
Mr. Broughton, I would like you to pull up 21C, something you wouldn't normally do, 781, 21C 781. There was a motion filed on February 10th. This will be pending in Division 6 by Ms. Suarez. Is your mom, Mr. Thomas?
Yes, sir.
Okay. By Ms. Suarez to modify the civil protection order. I'm not expecting you to know this statute, but I know this statute. The restrained party, in this case, Mr. Thomas, can't move for this relief within 2 years of it being granted, but the protected party can. And she is moving to drop the protection or the civil protection order. I know as a matter of law that doesn't affect the validity of your case, assuming the protection order was in place, but it might affect the equities of it. And I refer you specifically to her motion filed February 10th. Once you've had a chance to take a look at that, I'll bring you back to this case.
I have, Judge.
Okay. So, Mr. Thomas, first of all, let's start with this. Any objection to me quashing Mr. Thomas's warrant?
If he reports to CJSD to begin pretrial services today, I do not object.
Okay. Mr. Thomas, here's what I'm inclined to do, is to keep my bond terms as is, and then set you as soon as I can after March 17th, and that may change the dynamics of all of this.
All right. Your Honor, is there any way to just operate under the Truth in Lending Act and just surrender my principal for you to charge, discharge, and charge back to the
Hold the microphone a little closer to you, Mr. Mayor.
I was just wondering if the courts could honor the Truth in Lending Act and just charge, discharge.
Truth in Lending Act doesn't apply here.
Excuse me?
Truth in Lending Act doesn't apply in this type of case.
Okay, well, it falls under the bonds, doesn't it, the Uniform Commercial Code?
No, the Truth in Lending Act applies to creditor limitations on and disclosure. It doesn't even require a creditor to do anything at all. It just requires them just to disclose. But I'm not a creditor.
But you operate with bonds, so that's for a contract for sale, right?
Wrong. A bond isn't a contract for sale. It's a guarantee that you'll follow the court's conditions. If you don't, you risk forfeiting whatever amount was posted. That's why it doesn't fall under the Truth in Lending Act.
So this is a criminal bond, so this is a different deal. These are bond conditions. Again, here is my strong suggestion to you, is that we keep the bond terms as is. So I'm imposing criminal bonds. You can look at the statute for this is under 164101. You can write that down and Google it if you want. And it's Colorado Revised Statute 164101, then 102, 103, so forth. So,
But you have a JDF 73, 74, and 75, which is a bid bond, performance bond, and payment bond.
yeah, I don't know this particular JDF form, so I certainly use JDF forms all the time. So, but I'm, at least until my inclination, I think that's my week. And it is. I could set you the next day if you wanted me to.
Okay.
So, but then I would impose, but then I'm going to require you between now and then to comply with my order. And then we can readdress it on the day after your hearing in front of Magistrate Harden.
I don't have a problem with the court's orders. My problem is, Your Honors, I'm under a great big investigation team for some reason in Homeland Security and the generators, the X-ray units. 2 nights ago, they hit me on the road out there and ran my skateboard completely over and smashed it in pieces. And no matter where I go in this community, I'm basically a target, because they see me as an enforcer for the Aryan Brotherhood. I've done almost 9 years in the state of Colorado's prison system. Unfortunately, my appeals are not published. The jury's found me not guilty back in 2014, CR 540. No one's ever cleared my name. I just got out of Denver, Colorado, when Henderson basically sent me up there for mental evaluation, which they comatose me for almost 3 weeks straight under medication, and said that I was basically found incompetent to even stand trial. I came back here just to see my kids. I convinced my son to join up the Academy of GJPD with the police department, which he has. And now I'm starting to see kind of an immoral act that's going on, and I don't know where it comes from, unfortunately, but we will get to the bottom of it. But my policy, when I turn my UCC platform on, for some reason it starts blowing different technologies, and I heard a couple of generators around my mom's house go up and smoke, and so I shut the policy down and tried to basically get a hold of the United Nations to figure out why my policy is being tampered with.
I'm going to go out on a limb and say the United Nations has zero interest in getting involved with sovereign citizens facing criminal charges in the United States.
And unfortunately, I've been attacked. Me and my mom, my brothers, I think even my son. My 80-year-old stepdad has been dropped out in our front yard twice.
Well, Mr. Thomas, I'm looking, and there's no other Colorado cases pending against you. So here's what I'm going to do. I'm going to quash your warrant, and I'm going to direct you to report within 24 hours of right now to pretrial. I know you don't love it, but I want you to do that.
It's just a matter of getting around. That's all.
Right? That's okay, and then I'm willing to set you on the day after your hearing upstairs. Okay, so you'll go to that one, and then the next day you can come talk to me about modifying your bond conditions. Mr. Broughton's position might be different or more beneficial to you based upon what happens in front of Magistrate Harden. Okay? So bond conditions are going to remain as set. As to and I just look statewide, and I don't see any other cases with you. So bond conditions remain as set. I hereby quash the warrant in 26M311, 26M311. And then I set Mr. Thomas on the day after his hearing upstairs. Just double check that that's correct. That's at 8:30. I don't even mind setting you on the same day if you'd like. It's actually in front of Judge Rahm, not Magistrate Harden. I'll set it on March 17th at 9:30. March 17th, 9:30. So you'll be in front of Judge Rahm at 8:30 and be in front of me at 9:30. And go check in with pretrial, okay? But March 17th, St. Patrick's Day, Learn a lot about your cases, Mr. Thomas.
Okay,
Have a good day, sir.
thank you. One more thing, if you could address maybe the panel, there is some policy issues. I've been passed back and forth between mass jurisdictions. There is a conspiracy that's going on, and I'd like to know why they're using platforms to target AI technology and what frequency for mind control.
Yeah, I don't know, Mr. I don't mind. I don't know anything about that, Mr.
If
Thomas.
you'd like to study it a little further, it's Homeland Security Committee, number capitalized, look_up_Toronto.
Thank you very much, sir. Have a good day.
So that wraps up his first appearance. He was supposed to check in with pretrial services so his warrant could be cleared, but he didn't follow through and ended up getting arrested. Now, let's move on to his next appearance.
Okay, Mr. Thomas, let's call you up and let's move you along here. This is People versus John Thomas, 26M311, 26M376. Mr. Thomas, there is a warrant, or actually a couple of warrants for your arrest for failure to report to pretrial. We'll cover that in a second. You can have a seat. It's fine. Maybe they were resolved. You were arrested, so they're no longer pending. Have you reported to pretrial, Mr. Thomas?
So I got over there and they were closed in the evening, and then, of course, I'm walking, so I don't know how to get all the way down there with no money or nothing.
Okay.
So
We can walk from here. It's about 5 blocks from here.
I'm actually on 30 Road.
Well, right, but today you're here.
Yeah.
You can check in today.
But you'd said something that when they had dropped restraining orders, all this would stop, right?
I'm sorry, when they...
We just got out of Judge Rom's courtroom, and he had dropped all restraining orders.
Oh, is this civil cases? He dropped all restraining orders. Yeah, it's a civil case. Let's find out. The case, Mr. McCall, I'm going to refer you to a case, 21C781. That's 21. We're not calling that case, but I want to. What happened was that the protection order that had been in effect for quite some time, since August 10th, 2021, for the permanent of August 1st, 2021. So it had been in effect for 4.5 years. Judge Miller was even on this case. Was granted by Judge Rom. So the civil protection order, which looks like the basis of each of these, is now removed. I will tell you from a straight legal standpoint, Mr. Thomas, the protection order, when it existed, and you can violate it even if it's dropped later on, right? I mean...
Well, technically, Your Honor, the probable cause of the arrest was about some type of mental illness or a fire. You know, when the officer showed up, I was raking the yard.
Okay, well, hold on. So I just wanted to let you know that. Mr. McCall, I could send Mr. Thomas down to the FAC. You could talk to him. I know we have a fair number of people still here, but I will tell you later in the morning, because we don't have Mr. Fitzgerald or Ms. Lumpkins, we have a relatively light docket.
I'd actually like to.
Oh, it's yours.
Yeah, I understand.
I'm so sorry. I'm so sorry. Sorry, Mr. McCall. Mr. Broughton, my apologies.
I'd like to make a few phone calls and then perhaps a return date for Mr. Thomas in the FAC. I'll review the case. I'll speak with who I need to.
Is 3 weeks enough, Mr. Broughton?
Yes.
Ma'am, what's your name?
Janice,
Were you the petitioner here?
Yeah.
I will note, Mr. Broughton, the alleged victim in this case is right behind you. It may not be the only call you need to make, I'm not sure. But Mr. Thomas, I'm going to give Mr. Broughton some time to figure out what he wants to do. I'm going to sit you out in 3 weeks' time. I'll put you in the first appearance center. I'll give you your choice of a Monday, Wednesday, or Friday, April 6th, 8th, or 10th. at 9:30 in the morning. What is your pleasure?
Probably a Monday's fine.
You like the Monday? Okay.
I feel like this is just an awful lot of forced contracts for sale, Your Honor. And at this point, I know my principal's being passed around through all these different departments and everybody's opting in and opting out for the interest of judicial revenue. I think my family has been under a serious amount of attacks through the years, not only through the departments, but also Homeland Security's investigation teams. And I've been run down on the streets with my skateboard. They run my skateboard completely over. I mean, they come over and vandalize our house, and they're hitting us with squawk boxes, x-ray units. They got generators running, and I don't know how long I have to keep going to say, since 2014 CR 540, the juries have found me not guilty. The DAs have pulled affirmative defenses outside the jury's presence. And
So all we're talking about is what the people want to do on their next hearing.
the problem is the people keep passing me around as their principal when I'm not even subject matter jurisdiction.
Well, I'm going to give Mr. Broughton time to figure out what to do. The news that this protection order was dropped is hot off the presses.
Well, the problem I'm having is when officers show up and arrest me and then force me up at St. Mary's Hospital so they can do a mental evaluation through Colorado Springs or Denver. I've been through multiple institutions, multiple facilities. I've been through Mind Springs counselors, and I've had to investigate this so much now to where I know that through the Uniform Commercial Code and on the platforms of the Secretary of State, people can be violated through AI technology and watt frequency as long as there's generators.
Mr. Thomas, I'm just going to set you, okay? I'm going to set your hearing.
It's getting old, Your Honor. And there is a position when a man has to have some kind of defense, from the
I'd argue the best way to avoid trouble with the legal system is pretty straightforward. Don't commit crimes, be careful about what you believe online, and focus on making better, more constructive choices. If someone follows that path, things usually start improving. So that's the end of the video. The remainder of the hearing was just the judge scheduling the next court date. Hopefully, both individuals can get the support they need to eventually reintegrate into society. If you enjoyed the video, hit the like button. If not, hit dislike. And don't forget to leave a comment and subscribe with notifications on so you don't miss future content.